Good evening, everyone. I'm Terry Ryder. I'm an attorney here in Huntsville, and I've practiced here locally for 11 years now. Tonight I get the very distinct pleasure of introducing a very good friend of mine and my former law partner. Her name is Kerri Riley. We practiced together for a while in the area of employment law, which is her topic for this evening. She has a very distinguished legal career of her own. She graduated from law school. She's from here in Huntsville. She graduated from law school, and after law school for about 5 years, she worked for a personal injury firm. And for the 5 years following that, she worked for the city attorney's office here in Huntsville, representing the city itself. Since then, she's been in private practice, and for some of that time, we were law partners together. She practices in many areas, including personal injury and divorce law. The area that I specialize in and that we work together primarily in was employment law. And that includes all kinds of areas of employment law, including sexual harassment, discrimination, all types of discrimination, race, age, disability, unpaid wages. She is very good at giving both practical and legally sound advice to people who have problems at work. And those lawyers, there aren't that many of us here in Huntsville, Alabama that practice in that area. She is very accomplished, though, and we've had the pleasure of working together in the trenches, trying cases together, writing briefs together, and you name it. But her most recent accomplishment that I'd like to mention is a case that actually we took on together when we were law partners. We took it on. It was a sexual harassment case, a lady who worked for a pretty small company over in Morgan County. So small that we filed it in state court in Morgan County over there. This lady had a boss who had problems. He couldn't keep his hands to himself and couldn't say the right things to his employee and treat his employee the way he should. And unlike a lot of people, this lady had the presence of mind one day to bring in her handheld tape recorder. And she caught some of the interesting things on tape. Now, mind you, it was the kind of tape you'd think you might get from an inexpensive handheld tape recorder. It wasn't very clear, but it was clear enough. Although she tried to work it out, as you always do, we weren't able to do that, and it went all the way to trial. It tried last November over in Morgan County. She tried it on her own, and I was sorry I wasn't able to be there to help her since we had worked on the case for a while. And I guess the trial was going pretty well. The jury got to hear the tape, and so I think sometime during the trial she was having some asthma problems. Those old courtrooms can be killer on the breathing, and she was doing a little coughing. And anyway, they were appearing before the judge. The jury was on a break. And opposing counsel paid her a fine compliment. He said, "Judge," he said, "the only chance I have of winning this case is if Miss Riley loses her voice." Anyway, that's what she does. She tries those sorts of cases, and apparently the jury understood what her client had been through because she ended up with a jury verdict of $158,000. It's the first of its kind in northern Alabama in state court. Most of those damages were awarded simply to punish the company and its owner. Anyway, having said all that, I know you'll enjoy her speech this evening. It's my pleasure to introduce my dear friend, Kerri Riley.
Well, maybe we better quit now while I'm ahead. Oh, no. I'm really glad to be back here tonight. I've been here a couple of times before, both times speaking on different aspects of employment law. And tonight I'll try to talk a little bit about some areas in employment law that I haven't touched on previously, just in case you've all been staying up late at night and watching the old tapes. What I want to say is that I have some prepared remarks and I'm going to make them, but also as we're going along, if you have some questions, just put your hand up. I can take a break, and I'd prefer to actually answer your questions as they come up in the materials. And if we don't get to everything, then we'll talk about it afterwards this evening. Can you all hear me? Can you hear me in the back? If you can't hear me in the back, can you hear me? Good job. Okay. All right. I am in private practice. I am a sole practitioner, and we get a lot of telephone calls at my office asking all manner of things with regard to various areas that I practice in. But since we're talking tonight about employment law, a lot of employment questions. Most of the questions are are important ones, and many of them are common. And so I thought I'd start tonight with some of the most common questions that people have when they call my office that aren't the kind of questions that they can get answered by going into a lawyer's office usually, because that's expensive. And generally speaking, these questions aren't the kind that you need to spend a lot of money getting answered. So I'm going to answer some of those for you tonight. The major questions that I have of that nature concern unemployment compensation. Let me tell you, from a plaintiff's lawyer's perspective, I really like it when employers deny unemployment compensation, because if the employee was wavering on reporting some sort of behavior that is wrongful, that is illegal, and is a case, a civil case, denying the unemployment compensation is sure to get them into my office. So when I'm advising small businesses, and I do some of that, I always advise them to look at the employee, look at the situation, be skeptical a little bit of the supervisor's explanation before you deny someone's unemployment compensation. Because if that employee has been discriminated against based on their age, their race, their sex, been sexually harassed in some form or fashion, and you deny their unemployment compensation, if they weren't going to complain, now they are. So I get a lot of calls about unemployment compensation. Many times people want to know whether or not they can draw and under what circumstances they can draw and what happens when they're denied. And so what I tell people is, first of all, apply. You never know. Many times, in order to avoid a dispute, an employer will just let you have your unemployment. But there is a exception. You know, as you probably all know, if you quit your job, you can't draw unemployment, voluntarily quit. But there is an exception to that denial of unemployment compensation, and that is if you quit with good cause. And I have had a number of clients who have been sexually harassed at work who appealed the denial of their unemployment compensation and said, hey, I was sexually harassed at work. And more, the examiners are understanding that that is good cause to quit. It is called constructive discharge, and they get their unemployment compensation. Of course, people can be denied their unemployment for being discharged for misconduct at work, but there has to be a warning in advance. So again, if you're an employer, and I speak mostly to small businesses, large businesses tend to know these things, but small business owners maybe not. If you're going to discharge an employee, you need to document the warning of the behavior before you do so, if you want to deny unemployment. And conversely, if you're fired for misconduct but you weren't warned in advance, you can collect your unemployment in most cases. Some of the other reasons that you can be denied unemployment, basically if you have a drug test that's failed. But there usually has to be a warning, and that surprised me as I was looking at these, because I don't generally go through the unemployment law because it's something that I don't deal with on a regular basis except for quick questions for people. I was surprised to learn that you have to be warned that you can lose your job for failing a drug test. If you're not warned but you fail the drug test, apparently you still get your unemployment. So that was interesting to me. Yes?
If an employer, I'm hiring an employee and has them sign, this is the drug policy, you're going to pass a no-notice test, you'll be let go, is that considered warning?
Yeah, I would think so. I would think so, yeah. I would think so. You have to have a policy in place. Now, the next, any other questions on unemployment? Yes?
I know about a case like that. What if somebody is employed and then he gets an offer from another small business where they don't send you necessarily the letter that you are employed, and then after he quits the first job, he doesn't get the other one because the other business doesn't hire him? I know about a case.
Oh, well, that's a sort of a separate question. That's basically being promised a job, and then in reliance on that promise, you quit your employment, and then your job doesn't materialize. There's some civil remedies for that sort of situation if it can be proved. Now, the proving of it is usually the difficulty in those cases. Yes.
How is it that an employer can stop a person from getting unemployment benefits? What is an employer, why do they have a say in what you get or not get as a benefit?
Well, they have a say because they have to pay. The employer pays and I'm a small business owner, so I probably should know this, but I just basically do what my accountant says. But I know I have a rate that I have to pay, a percentage of my employees' salaries, and that rate is more or less based on whether or not my former employees draw unemployment. So the employers get a say-so because it affects the rate that they have to pay in their unemployment tax. Does that answer your question? Okay.
It's not like Social Security, when you pay in and you get the benefit, certain circumstances occur.
Yeah, and
So nobody can stop you from Social Security. No, there's no outside influence other than being, having the benefit. But in this case, you're saying the employer does.
they do. They get asked by the examiner what the reason for the person being let go. If it's a layoff, they draw their unemployment. But if the person quits without good cause, and of course the employer is likely going to say, well, they just quit, and the employee is going to say, well, yeah, because he was chasing me around the desk or something of that nature. So that's how that comes into play, and then there's a decision, and then that decision can be appealed, on up the administrative path. That's how that works. Any other questions before we leave unemployment compensation? Okay. Probably the second most frequent phone call I get from the members of the public who just need advice and need to know what to do is in the area of the Family Medical Leave Act. And I actually bring cases under the Family Medical Leave Act as opposed to unemployment, where I usually just give some quick general advice. The Family Medical Leave Act is a federal statute that if you are a qualifying employee, meaning that you've worked a year and at least 1,250 hours for a particular employer, and if your employer is a qualifying employer, meaning that there are at least 50 employees within 75-mile radius in their business, then in most cases you are entitled to have 12 weeks off for a birth of a child, for adoption or placement of a child with foster care, for a serious health condition of a family member, or your own serious health condition. And I get many, many questions about this. I think this is an area where employers frequently are not fully informed about the law too. I see quite a few abuses in this area, and I bring a fair amount of cases in this area.
That's unpaid leave, right?
It is unpaid leave, or the employer can require the employee to use up all of the paid leave they have coming to them as a part of that 12 weeks. So that if you have 3 weeks of vacation and a week of sick, then you have to take all of that till it's gone. And then how many weeks left, say in that case would be 8 more weeks, then on the very next day you better have yourself at work or you are fired, and there's nothing that can be done about that.
And that only applies to employers who have more than 50 people working for a small business exempt?
That's correct. That's correct. Also, it applies generally, but it does not apply to certain highly compensated employees, certain key employees. If the business doesn't run without you, then you are probably not going to be covered under the FMLA. But in most cases, if the business is large enough and you're someone who is going to be utilizing that leave, then you're going to be covered. You know, if you're the CEO of the company, well, you wouldn't be covered, but you wouldn't be taking 12 weeks off anyway. You know, you're going to be on your cell phone at home or on your computer or whatever. FMLA leave is subject to your doctor, what I say, standing up for you, but your doctor has to come in and certify that you have a serious health condition. And that means something that is either inpatient in the hospital or something that requires continuing treatment by your physician, continuing time off and continuing treatment. You know, a 3-day cold is not going to cut it, and I get a lot of confusion about that. You also have to let your employer know if the leave is foreseeable. If you know you're going to have surgery, and I had somebody who's going to have bariatric surgery, and you know they know about that 2 or 3 months in advance. You've got to let your employer know about it 2 or 3 months in advance then, so that they can plan ahead for your period of being out of work. In addition to that, you can have leave on a reduced leave schedule, not for the birth of a child or adoption or foster care placement, but for if it's medically necessary, you can have that leave on a reduced leave schedule. But your employer has the right to transfer you around to a different job that will accommodate them better. Now, if you're covered under the FMLA, you do have the right to have your job back at the end of 12 weeks, or at least an equivalent job at equivalent pay and benefits. Your benefits cannot be terminated. You can't lose any of your benefits for taking that time off. Now, if you're not going to gain seniority for that time, I mean, you weren't working, but you do have those rights. And we do see a lot of abuse in that area, a lot of situations where someone is sick, and you know they notify their employer as soon as possible. I mean, you know, seeing people go to the ER in the middle of the night and end up in the hospital a couple days and notify their employer within a few days. And the employer says, no call, no show, you're fired. Well, that will not fly under the FMLA. And I do see quite a bit of that. The statute of limitations for bringing an FMLA case is 2 years. It means if you don't bring it to a lawyer and that lawyer file a lawsuit on your behalf within 2 years, then it's gone, unless it's absolutely willful, which would be very hard to prove. Although I've seen some cases where it just seemed pretty willful to me. The other thing that I get a lot of questions on is COBRA benefits. A lot of people don't understand about their COBRA. And again, these are the sorts of things that no one makes an appointment with a lawyer and comes in and pays for a consultation fee to learn about these things. But I mention them because I get a lot of phone calls where people just really want to know the answer to this and that. And there's an awful lot of that sort of information out on the internet. But if you're severed from your employment, your employer, under most circumstances, if it's a large enough employer, is obliged to offer you those continuing health care benefits. And it takes about, there's a pickup period is what I think of it as, where for 90 days you can go back and pay your back premiums. If you don't have another job with employment, with health care benefits within that 90 days, you can go back and pick up those first 90 days and pay your premiums, and then your health care provider has to pay your health insurance benefits during that 90-day period. This is for after you lose your job. And those carry on for 18 months, except in domestic, and we won't go there, but it carries on longer after that. Does anybody have any questions on FMLA issues, Family Medical Leave Act issues? Sure.
Can you use it more than once?
You can use it more than once, but you've got to have that year in between. You know, you've got to have that year in between. Also, you cannot be terminated, or I say discriminated against, but terminated is what you usually find, because you've notified your employer that you're going to use those benefits. In the instance I gave a few minutes ago about the patient wanting gastric bypass surgery, You know, if he notified his employer he was going to do this, well, then they don't get to fire him because he's going to use it in 3 months, you know. So that frequently comes up. You see some things like that sometimes that seem real suspicious. Again, proving it. Those little voice-activated tape recorders, I'm all about those. But don't do it outside the state of Alabama, because in other states, the laws are different. In our state, it's allowed for you to tape record any conversation that you are part of. Can't leave it laying around. But if you're part of that conversation, you can tape it. You don't have to tell, unless you work for the government or in some employer that has a rule against it. And then, of course, you're going to violate some work rules. But don't take that across the state lines, because I don't practice law in Tennessee or Georgia or anywhere else, and I don't know what their rules are. Okay, any other questions on the FMLA? Yes?
If you had a serious medical situation and you would be granted that 12 weeks of leave, you had a serious complication and you could not go back to work in 12 weeks, is there any, time?
Nope.
You could go back or
Grace. Grace. You know, if you're valuable enough to your employer, they may work with you. And speaking of grace, I don't know if anyone has mentioned to you at any time during this term of People's Law School that in Alabama we have what is called employment at will. That means that unless there is some intervening law, some intervening federal statute, some intervening state statute, but generally speaking, as employees in this state, we have no rights, none. We are employed at the will of our employer. We can be terminated at any time for any reason. Good reason, bad reason, wrong reason, stupid reason, unfair reason. You can be terminated. And again, on the top 3 lists of things that I get called about, unemployment, FMLA questions, and employment at will. Because people say, yes, but they said I did this and I didn't. Or, yes, but I'm the best employee that they have. Employers have a right to be stupid. They have a right to run their businesses badly. They have a right to run them into the ground. They can do all of those things, and you have no recourse. We have a fair number of transplants to Huntsville, to Alabama from other states where the employees have rights. And so I see a fair number of people in my office who come in sort of puffed up, for lack of a better word, a little huffy, you know, and they leave after I've given them the discussion about grace. You know, go back to your boss and say, I'm terribly sorry I lost my mind, you know, because you have no rights. And so that's something that I think is important for people to understand. Now, that does not mean that you can get fired because of age, race, sex, disability, national origin, creed, etc. You have federal protection as long as your employer has 15 employees. If there are 14, guess what? You can get fired because of your age, your race, your sex. Just out and out. I don't like, no men in my office. Not going to have any men in my office. Well, I only have 3 employees, so I can do that. Might be foolish, might be stupid, might be immoral, but it's not illegal. 15 employees and the ball game changes. That's a federal statute. In Alabama, the state of Alabama, the only one of that list that is protected by our state is age. So in its infinite wisdom, the state of Alabama thinks that it's wrong to fire old people. But if you're a woman or disabled or whatever, you know, we're not there yet. The other employment protections that we have in this state that are federal is the FMLA, which I've already talked about. We have the Rehabilitation Act, which is sort of a precursor to the Americans with Disabilities Act. And of course, in Huntsville, a lot of people work for the government, and so they're aware that we also have whistleblowing statutes that provide protections when you report government fraud or wrongdoing of some nature, or filing false claims for reimbursement by the government, then you get fired because of it, or terminated, or transferred to Alaska, or whatever, then you can file suits on that. As far as state laws go, well, we have age discrimination protection, and we have workers' compensation protection. You cannot be fired for filing a workers' compensation claim. And as far as state law goes, that's kind of it. That's it. So that was a long takeoff on your question, but when I said grace, it brought all this to mind of the clients that I've seen in my office who came from states other than Alabama, who were really, really surprised, and in some cases upset to learn that they needed to have not been insisting on their rights in the workplace because they didn't have any. Any other questions on the FMLA? Okay. All right. Well, on to Title VII, which is something I do a great deal of, and this is the statute that protects employers in the federal courts, unless it's age, in which case you can go to state court, protects employees from being discriminated against based on their age, race, sex, national origin, disability, etc. And you will also hear the Pregnancy Discrimination Act, which is a form of sex discrimination. That's an amendment to Title VII, which protects pregnant women from being terminated based on the fact of their pregnancy. And the ADA, which is the amendment to Title VII, which protects from being discriminated against because of disability. Does anybody know what you do if you feel that you have been discriminated against because of one of those protected reasons? Does anybody know what step number 1 is? Besides call me, of course, bingo. Now, how soon do you call me? Immediately. Who said that? Immediately. Really good. Y'all are hot. I can tell you're into it. I expected senioritis tonight because I understand tonight's graduation, but anyway. You have 180 days if you have been discriminated against because of your age, race, sex. I'm not going to go through the whole list because I'll leave one out. To file a claim with the Equal Employment Opportunity Commission in Birmingham, Alabama. It is a brief statement of your claim, and you swear to it, and you mail it down there, and they put a file stamp on it. And that has to happen within 180 days of the wrong thing that you think happened to you at work, and I use that broadly, the wrong thing, or the first time you knew there was going to be a wrong thing. Because if they tell you on the 1st, your last day of work is the 30th, you got to count that 180 days from the 1st when you were told. You must do that or your rights under Title VII are lost. Question in the back.
In emphasizing your requirement for immediacy, in some cases, it requires within 60 days. Federal. Yeah. I'm speaking, and thank you. I am speaking of, and it seems like there are some that are 45 days too. I'm speaking of general private employment, and I should have made that known at the beginning because, and thank you, I appreciate that, because we have so many government workers in Huntsville and the surrounding counties, and the rules are different when you're a government employee. So really immediately if you're a government employee, and I always have to look them up because many of the government employees start the process without a lawyer and get their lawyer sort of later on into it. But yes, in some cases, especially if you're a government lawyer, it's quicker than that. But general private employment, it's 180 days. Anybody else with a question or comment? Yes?
What if you are terminated, but you really don't know that you are terminated because of your age, and then after about maybe a month or 2, you have concrete evidence that that was the cause?
Well,
would that work with the 180 days?
Well, get yourself to a lawyer, number 1, quick as you can.
There are some cases that I have seen where the reason for the termination did not become apparent until later. And I'd have to get on my computer and research that. But I have seen cases about that. I have seen in some jurisdictions some exceptions made in some cases for situations like that. But again, that's what I call an interesting legal question. And my first rule of thumb is to do things early so we don't have interesting legal questions. The less interesting legal questions we have, the better case you have. But if that were to come up, then of course get to the lawyer quick so some research can be done. There are also cases where you can piggyback onto someone else's discrimination charge. So if a whole group were terminated because of age, and 3 or 4 knew and filed their charges, and then the rest of them didn't know until afterwards, you still might be able to piggyback in on their charges. So there's some exceptions. Yes?
Isn't it real hard to prove? For example, the employer may say, oh no, she was terminated because she cannot lift 50 pounds. Nobody else was expected to lift 50 pounds.
Yes, it's real hard to prove. You're absolutely right. The easy proof is I don't want any gray-headed ladies working for me, you know.
Yeah.
Nobody over, which is a number I don't even say out loud, okay? So that tells you what birthday I'm approaching. But, you know, that sort of thing. Those are the easy cases. And usually employers are smarter than that. They really are. So you have to look at other factors. It can be done, but you have to look at other factors. And I saw another question. No, maybe not. Okay then. All right. So the first thing that you do, if you feel you've been discriminated against, is to get yourself to a lawyer. Get that charge filed. Of course, get as much information as you can. Names of other people if you think there's a group been discriminated against because of age. Names of the past secretaries if you think that the boss may have had a habit of chasing them around the desk. You know, get as much information as you can. Get your handbook. Get it in. Then the EEOC gets an opportunity to investigate. And they get 180 more days to do that. They're actually a lot better than they used to be. Used to would have said, and so the charge sits there for 180 days, and all that means is you can't do anything for that period of time. But they actually do now, they really do make an effort now to contact your witnesses and get some information to see if that can be helpful to you improving your case. Not every time and not every investigator, but they do try a little bit. Then at the end of that period of time, they will issue a determination. Either they find cause to believe that discrimination has occurred, or they find no cause to believe, which basically means they couldn't prove it. Now, a cause finding is a good thing if you're a plaintiff. A no cause finding is not necessarily fatal. Generally, they don't have the resources at the EEOC to do a thorough investigation, and many times your lawyer can do a bit better job and prove it up if we need to. After that, the EEOC issues what's called a notice of right to sue, and once you have that little piece of paper in your hand, you have 90 days to get your lawsuit in. Otherwise, again, your rights are terminated under Title VII. Did I see another hand? Maybe not. Okay. Now, the thing that I try to do when I have these kinds of cases is that I try to time it so that we don't ever let the charge sit down at the EEOC longer than 180 days. So you've got the first 180 where you might be going to file it, then another 180 for the EEOC, and that's fixed. You can't do anything about that. Well, if you are going to also bring some charges, some claims under the state law of Alabama, your statute of limitations on those types of claims is usually 2 years. So you want to bring all your claims in one lawsuit. And you can see how you get kind of in a bind, you can get in a squeeze. if you let that charge sit down at the EEOC longer than 180 days and they're investigating, and I've seen them investigate for 2 or 3 years, well, that's fine for the EEOC, but if you had some state law claims and you were waiting on them before you went to a lawyer, those state law claims are going to be gone in most cases. So, so that's another reason why you want to get in and get with somebody who can help you out before you wait around on the EEOC. It's not necessarily a good idea to do these things on your own. Now, I'll talk about my my particular. I wouldn't say it's my favorite area of practice, but because the circumstances that give rise to it are generally pretty traumatic. But the area of practice that I tend to do in this northern Alabama area, and hardly anybody else does, and that's sexual harassment. I don't know why I fell into that, but I do it, and many other people don't. Those types of cases are complex because you have both the federal statutes that you have to look at your causes of action under, and then you also have state law causes of action that aren't sexual harassment, but they can be crafted to fit your facts, so that you're looking at a federal Title VII claim based on sex harassment, and you're looking at a state law set of claims, invasion of privacy, which of course there's not much more private than that area of your life, outrage, which is intentional infliction of emotional distress, and in some cases are so egregious that it would be impossible for a reasonable thinking person to think other than that the person doing this intended to upset the person on the other end of the sexual harassment. Assault and battery, which is wrongful touching or wrongful fear of being touched. And those claims are state law claims that can be brought together with the federal claim, and you have different remedies for both. So I try to bring all those claims in one lawsuit and file it in federal court. Some of the statutes have caps. The federal statutes have caps. The state statute doesn't have caps. The federal statute allows you to recover attorney's fees, which means the employer, the bad guy, the employer or the person acting wrongfully pays the attorney's fees, but that's not the case in state law. In state law, everybody pays their own attorney's fees, usually on a contingency fee basis, but it comes out of their award. So there are different reasons why you'd want to have both types of claims. In the case that I tried most recently, the employer had less than 15 employees, and we just didn't have the vehicle to go to federal court. Couldn't go there. Couldn't get there. So I had to take these state law statutes: outrage, invasion of privacy, assault and battery, and in that case also negligent supervision of the person, and brought all those claims in state court, and fit our facts into those causes of action so that we could get this lady some help, because of course when she complained she got fired, and single mom, the whole bit, needed the job, couldn't find another one. Took us 3 years. So these cases are not, they're not quick, they're not easy, they're usually fought. There's very rarely an insurance company out there for these types of claims. Usually you're looking directly at either the corporation or the small business owner themselves, who maybe actually did the action for compensation for your plaintiff, and they don't want to pay. They'll go to their grave saying they didn't do it. So these cases are long and hard fought kind of cases and take a long time. Many of the considerations that women have traditionally faced in deciding whether to report a criminal sexual assault are the same types of considerations that women face in deciding whether or not to bring these kinds of civil claims. Yes?
Sam, one of the other attorneys had mentioned that some of his cases cost him over $100,000 to run the case. you're talking about complexity, 3 years, et cetera, and it sounds like there's a lot of time and money tied up in this. What sort of attorney fees would be, say, norm for a case
Like that?
like this?
Well, the kinds of cases that cost, like you said, an attorney might have $100,000 of their out-of-pocket money in a case. Those cases, in my experience, have been products liability cases. And the only kind of case I've ever had that had that kind of my personal, expense in it was products liability lawsuit. An employment case is, generally speaking, taken on a contingency fee basis, which means I put my time in, and then if the employee recovers, then I get a percentage of that recovery as my fee. If you're in federal court, then that's why we like to bring these all together in federal court. Then I keep up with my time. I do billable timesheets in tenths of an hour. And if we are successful, then I file a fee petition with the federal judge, and he says I was either worth it or I wasn't, and what hourly rate he thinks I'm worth, and whether or not I should have spent 2.5 hours instead of 3 on something, and and then you get paid that way. You have a question?
Yes, you said that it was a small company, for example.
Uh-huh.
Well, if they don't really have $150,000 or something like that, they might never pay, and how will you try to recover it? No matter what the judge says, some of the small companies, they're not insured, and they don't really have it unless they liquidate the business or something.
Right. Well, and you've just raised a really good question, and the question was, what if your company is not solvent, or what if they have minimal assets compared to the verdict? And let me tell you, this is a business issue for a plaintiff's lawyer like myself or like Alan. We learn at the very beginning of our practices that we can't help anybody if we can't stay in business. Okay? It is a business. You do help people, but you're helping them on your time and your dollars, and therefore you have to have made some money to be able to do that. So the first thing I always do is I look to see if the potential defendant is going to be solvent. I'm certainly not in the business of taking away people's houses and cars and kids' college educations. If you're wronged by someone who doesn't have the means to be responsible for their wrong, the financial means to be responsible for their wrong, then you are basically self-insured. If you're fired by someone who, wrongfully fired by someone, but they don't have the means to make you whole, then you've lost your job, and hopefully you had some money in savings to take care of that. That's just the way of it. And I hope that yes.
How long before she was paid?
My client? Well, in that particular case, it took 3 years to get the case to trial. Then we tried it for a week, and we got a very nice verdict. We got compensatory damages for the time that she was out of work. The jury did not award compensatory damages for her emotional distress for being out of work. She was out of work several months and a single mom, so it was very, very stressful. They did not award emotional distress damages, and they didn't award mental anguish damages. And the reason that was a difficulty for us, I think they got very wound up in the punishment aspect of it. They were outraged at the behavior, outraged at the behavior. But in the state of Alabama, because of the success of certain political groups in capping certain types of damages, there are now guidelines in the Supreme Court about the amount of punitive damages versus the amount of actual compensatory damages. And since we got relatively low compensatory damages, $8,000 and $150,000 punitive, which this person was very solvent. I mean, they could have written the check out of their checkbook before they left the courthouse. So there was no question about that. But because of that disparity,
then there was a long review process by the trial judge. Now, we're not even to the appellate courts yet, by the trial judge. And at the end of that review process, he reduced our verdict down to 96 plus the 8. So we ended up with 104 in interest, you know, because of the 4 months. And then they did not appeal. So, you know, at the end of 4 months after trial, she did get paid. But if there had been an appeal, you could have added another year onto that. Now you would have been getting interest on that verdict, and it's 12% interest in the state of Alabama, so can't hardly get that for your money. Yeah, that was pretty good. I was like, oh, I don't care, appeal, you know. But that's how that works. But I'm not sure I completely answered the question about the fees. If I'm working on a percentage basis, like in the state court case where they don't award attorney's fees, and in that case there was no award of attorney's fees because there's no vehicle to recover, then on an employment case I generally take that on a 50-50 basis. And where my clients have the ability to do so, I ask them to put up some money for expenses, the out-of-pocket, so I don't have to be getting people divorced to pay for the out-of-pocket deposition costs and things. And that's just the economics of handling an employment law practice. It's the part of my practice probably that makes me feel good, because I feel like I'm making the workplace fairer for all kinds of people, but it's not the most lucrative part of my practice, which is why, another reason why it's awfully hard to find an employment lawyer. Another question? Okay. All right. Now I've totally lost my place, and we've got about 5 more minutes. So I think we'll talk about the Americans with Disabilities Act a little bit. Anybody else have any questions on sexual harassment? One of the things that I've found in Huntsville is that we have very little of it. We have such a high percentage of large corporations here who train on sexual harassment, and then the government employees have all been trained on sexual harassment. And what I have found is that they know what not to do, and it's not happening. It's just not happening, which is a good thing. The odd thing that I found with my other case was that traditionally, you know, engineers are really hard for plaintiffs to have on the juries. We have so many engineers here because they just pick everything to death, and don't generally like to award significant verdicts. There are probably a lot of reasons for that, but I tend to think it's because that we've gotten away from understanding what it is to work with your back, what it is to work with your arms and legs, and so how valuable it is if that kind of thing is hurt. So, you know, you'd never accept any amount of money to be hurt, but nonetheless, you find a lot of stereotypes about not having engineers on your juries for personal injury type questions. Now, for sex harassment, the first case I tried, I got rid of the engineers. Get rid of the engineers. And actually, that was Terry. She was like, get rid of that engineer. And I'm going, I don't know. I kind of like engineers. I have an engineering degree, so I can think I could talk to him. She's going, get rid of it. Well, that one didn't turn out so well. But this last one, I said, okay, that's it. I'm over here by myself. I'm keeping the engineers. And what I've learned is that they were incensed. I mean, they knew this was wrong. They could quote the sexual harassment definitions out of their handbooks. And, you know, they were after this guy. I mean, you know, if that had happened to them, boy, they'd have been out of work, out of a job, out of whatever. And the fact that this was a small business, I mean, they were just incensed that the work rules were different for employees of small businesses than large businesses. They said, we're going to impose the same standard all the way around. So, I really enjoyed having my engineers on that jury. It was a good experience. Okay, enough of that. On to the Americans with Disabilities Act. Does anybody generally know what the Americans with Disabilities Act provides for? No. Okay, well, disability discrimination, of course, but it's actually very technical. you have to have, for example, I'm blind as a bat. Okay, I'm blind as a bat, but I have had cataracts, and therefore I have lens implants. All right, I am without those lens implants. I mean, literally, I would be blind. I mean, I couldn't see anything, and I would be disabled under anybody's standard. I couldn't walk 2 feet. But with my lens implants, I'm standing up here with nothing on my eyes. I do have my readers over there, but I'm too vain to wear them. And so, of course, I'm not disabled. That is not a disabling injury. If you're going to be disabled according to the Americans with Disabilities Act, you have to have the kind of disability that can't be remediated by appliances or medicines or whatever, can't be kept into control. And if you are disabled, there's a long technical definition of disability that I'm not going to go into because we're getting very close to our 2-minute warning. But if you are disabled, under that definition, then your employer has to offer you reasonable accommodation in the workplace. But you have to ask for it, and you have to say what accommodation that you need. And if you happen to be in that situation, it's really a good idea to get some advice on the front end before you get into a situation where you're having to ask for grace from your employer. And I think I probably better leave it there because we're at the 2-minute warning, but I have enjoyed this evening. Thank you for having me back.
Thank you so much. Ladies and gentlemen, as our first graduate, we have Ms. Alex Moquin. Alex, thank you so much for being here. She'll graduate in about a month.
Congratulations.
There you go. Now, let's see. Our next is Elizabeth Lipsey. Where's Elizabeth? Hey, Elizabeth. Wasn't that great? Hey, listen, tell all these people, the first time you ever came here, where was this People's Law School?
Butler High School.
She was one of the original people.
That's
Tell
right.
them about it in 1985, wasn't it?
Yes, sir.
How about that?
Butler High School. I had forgotten all about it. My son reminded me. So we already did this, Mama.
Isn't that great? But you know, and don't you like it better here in the courtroom?
Oh, yes.
It's much better. Judge Rodenhauser lets us stay here, and so does the mayor.
That was very nice.
Isn't that great? Well,
Yes,
thank
sir.
you, Ms. Lipsey.
Thank you.
Congratulations.
We're bringing up the couples right now. So the next couple is Catherine Mitchell and Heidi Collier. They go everywhere together. Yeah, here we have. There you go. Here you go, Catherine. Catherine's a retired teacher herself, and Heidi is organizing I believe this year, the Pinamunda families who are here in Huntsville. You're in charge, aren't you?
Yeah.
Going to have it here in a month or so. Thank both of you for coming. Good to see you.
Thank you.
See you next.
Congratulations.
Did you teach Kerri?
She did.
Hey, how about that? Isn't that wonderful? Did y'all know Kerri was the valedictorian of her class, by the way? Girl. And also I'll mention about Kerri is that she was the valedictorian, but y'all were talking about these, or bad-mouthing these engineers. And I see a lot of them in the room, and she's a chemical engineer as well as a lawyer. So I guess both sides of her brain works. Now, where's Miss Lavinia Spillman? Miss Spillman, did we spell your name right on this thing? Yes. It's like, what do you want me to be? Right. Is it one L or two?
It's one L.
Okay, well.
But it's the Lavinia.
Oh, gosh, I tried. Look, did we really?
Yeah.
What's wrong with that, Lavinia?
It needs an I in there.
Thank you
And
so
we'll
much.
get one fixed for you.
Thank you.
Congratulations.
Yeah, Miss Spillman taught at Grissom about 30 years ago, I remember, and glad to have you. Now, Mr. Bill Russell, you need to be teaching this class, I think. And if you don't, we may have Mr. Patterson come, but thank you, Mr. Russell, for coming.
Appreciate it. It's been a learning experience.
Well, I look forward to seeing you next year.
Okay.
Again, Mr. Russell is the Dean of the People's Law School. He has been here more than anybody. How about that? Isn't that great? In a row, like 8 times.
9.
9. How about
9 years in a row? I'm impressed.
that? He could teach. We may have him
I
teach
know.
us things.
Appreciate your time.
Congratulations.
All right. Now, Mr. Patterson, come up here. And I want you, Mr. Patterson, by golly, and Mr. Patterson's right behind him. He's been here like 8 years in a row. And tonight you brought your granddaughter. Let's
Sure
see.
did. She wants to know where all the smarts are when it comes to law.
Well,
She found out.
well, there you go. I see who you're pointing to. But thank you so much, Mr. Patterson.
I've enjoyed it. And like the furniture, I'm going to be perennial.
Thank you so much, sir.
Congratulations.
Thank you for coming.
Alan, next year you need to award 10-year trophies.
A 10-year. Hey, okay, where's Val Moore? Did Val, there you are, hiding. There you go. Come here, Val. Val's my friend, and we go way back, don't we, Val?
Yes, we do.
Now you used to teach at Jones Valley.
I didn't teach, I just helped run the school.
You just help run the school. Well, that's right. We have so many educators here, and Val Moore now, and she's been to the law school, what?
3 years.
3 years in a row. Have you enjoyed it?
Absolutely,
Would you come next year?
yes, and the People's Law School is a asset to the community. It's a good way to inform the public as to the different areas of law.
Well, thank you so much. And here's your diploma. See you next year. All right. Sigrid, let's see. Sigrid Burge. Now, I didn't get you your tape, but I promise you I will. She's got several requests of particular tapes she wants me to get for her, and I will, by the way, and for the rest of you. If you need them, we'll get them. Just call my office later on. But thank you for coming.
Thank you for having me, and I enjoyed each and every night.
I enjoyed it too.
Thank you
so
so
much.
much.
Good to see you.
Good to see you.
Thank you.
Let's see. Pamela Ebling Belt. Pamela's daughter, by the way, is going to go to law school here directly, and I'm excited she looks so much like you. Pamela, thank you so much.
Thank you. I enjoyed it immensely. It was, like I said, the best $40 I ever spent. So.
Isn't that great? Thank you.
Good questions.
Yeah. Again, the cost is only about $40, which just about pays for the book. But we film these programs early in every year when we can, and then and we air them over the year as they are produced. This is the 220th program that we've been able to film for television, by the way, and there is now an archive that the Alabama Trial Lawyers keeps of all of the previous tapes. If you ever want to request them, we have almost all of them in the archives. Now, Marvin Booker, where's Mr. Booker? There he is. Mr. Booker, I remember him because he's like a bookend. That's what they said when Alabama won that football championship. Johnny Major said they wouldn't have done it if they didn't have those two bookends. And every time I think of Mr. Booker, I think of those bookends. Mr. Booker, thank you so much for coming. Please come again.
Congratulations.
I hope so. And John Noterman. John Noterman is my friend. I want you to know his mother, Margaret Noterman, used to come to the People's Law School. Bless her soul, we miss her. But John is now following in her footsteps, and I thank you so much.
Thank you.
Good to see you, my friend. Here's your diploma. Well, let's see. Well, that will conclude the People's Law School for this year. Thank all of you for coming, and we'll see you again. Thank you.